Born into a modest family, the future legendary judge learned the value of fairness early on. Her parents, both educators, instilled in her a deep respect for justice and equality. Despite financial struggles, she excelled in law school, where she developed a reputation for questioning outdated legal doctrines. Her core belief, that the law should serve people, not the powerful, guided her career. She often clashed with superiors, but never compromised on ethics. This unyielding stance earned her both admiration and resistance, setting the stage for her revolutionary impact on the judiciary. As a young judge, she faced systemic sexism and political pressure, yet she refused to conform. In one early case, she overturned a biased ruling that favored a corrupt official, despite threats to her career. Her boldness inspired junior lawyers and activists, proving that change was possible. She championed transparency, pushing for courtroom reforms that made trials more accessible to marginalized communities. Her work exposed flaws in the legal framework, forcing institutions to confront their biases. By breaking these barriers, she paved the way for a more equitable justice system. One of her most famous rulings freed dozens of wrongfully convicted prisoners, exposing police misconduct. Another case granted protections to undocumented workers, setting a national precedent. She famously stated, "The law must protect the weak, not shield the powerful." Her decisions often sparked public debate, but she stood firm, knowing the human cost of inaction. Families reunited, policies were rewritten, and corrupt officials were held accountable, all because of her fearless judgments. These cases cemented her legacy as a judge who truly served justice. Her career wasn't without backlash. Powerful figures accused her of activism, and some media outlets painted her as a disruptor. Death threats and smear campaigns followed, but she remained undeterred. "If the system is broken, it must be challenged," she declared. Even when her rulings were overturned, public support grew. Critics couldn't ignore the tangible good her decisions brought. Children saved from abusive systems, communities granted clean water, and corporations fined for exploitation. Her controversies only highlighted the need for reform. Today, her rulings are studied in law schools, and her speeches inspire new generations. Foundations in her name train judges to prioritize ethics over politics. Though retired, she remains a vocal advocate, warning against complacency and justice. "The fight never ends," she says. Streets and courthouses now bear her name, but her true legacy is the lives she changed. From a small-town girl to a global symbol of resistance, her story proves that courage can reshape the world. The system feared her because she refused to let it fail the people. Throughout her career, she was known for her powerful dissenting opinions, which often became the foundation for future legal reforms. In one notable case, her lone dissent against a corporate-friendly environmental ruling later inspired nationwide policy changes. "Dissent is not disobedience, it is democracy in action," she famously wrote. Her willingness to stand alone earned her respect even from opponents, as history repeatedly proved her right. These dissents were not just legal arguments, but moral manifestos, calling attention to systemic failures. Over time, many of her minority opinions were adopted as majority rulings, proving that justice delayed is not always justice denied. Beyond the courtroom, she dedicated herself to mentoring young lawyers, particularly women and minorities facing discrimination in the legal field. Her workshops on ethical jurisprudence became legendary, with many attendees later becoming judges themselves. "The law is only as strong as those who uphold it," she often told her students. She founded a scholarship for underprivileged law students, ensuring that talent, not connections, determined success. Many of her protégés now lead human rights organizations, proving that her influence extended far beyond her own rulings. Her mentorship created a ripple effect, shaping a new generation of fearless advocates. Her work transcended borders, with foreign courts citing her judgments in landmark human rights cases. When a European tribunal referenced her ruling on refugee rights, she humbly stated, "Justice has no nationality." She advised constitutional reforms in developing nations, always refusing payment. Justice should never be a business. Her speeches at the UN and International Criminal Court called for judicial independence worldwide. Though some governments banned her books, Underground translations spread her ideas further. She became a global symbol of resistance, proving that one judge's courage could echo across continents. Her commitment came at a high personal cost: threats to her safety, strained family relationships, and years of surveillance. "If I had chosen an easy life, I would have betrayed myself," she admitted in a rare interview. Colleagues recalled her working through illness to finish pivotal rulings. Even after an assassination attempt, she returned to the bench the next day. Her unwavering resolve stemmed from a simple belief: when the law fails the vulnerable, we have failed humanity. Though she rarely spoke of her sacrifices, those close to her knew every victory was hard-won. In her final public address, she warned, "A just society is always one generation away from losing its freedoms." She established a watchdog organization to monitor judicial corruption, staffed by her former clerks. Even in retirement, she reviewed pending cases, sending detailed notes to judges. Her autobiography, Without Fear or Favor, became a manifesto for reformers. Now in her 80s, she still attends protests, her presence a silent rebuke to tyranny. "The robe I wore was not armor. It was a responsibility," she says. Her life reminds us that justice is not a destination, but a relentless march forward. Her judicial philosophy was often described as the law with a human face. While strictly adhering to legal principles, she famously considered the real-world impact of her decisions. In a controversial inheritance case, she ruled in favor of a caregiver over distant relatives, stating, "The law recognizes blood, but justice must recognize love." This approach sometimes drew criticism from traditionalists who accused her of judicial activism. Yet, her opinions were meticulously reasoned, often citing historical precedents alongside sociological data. She maintained that judges shouldn't just interpret the law, but safeguard its spirit, especially when literal interpretation would produce absurd or cruel outcomes. Her ability to balance cold legal analysis with profound empathy became her trademark. The establishment's resistance peaked when she blocked a government initiative that would have restricted press freedoms. Overnight, she faced disciplinary proceedings and a smear campaign portraying her as anti-state. Anonymous officials leaked false claims about her personal life, while pro-government media labeled her the activist in robes. What they didn't anticipate was the public outcry. Thousands marched with copies of her judgments, and international bar associations issued statements of support. The disciplinary case collapsed when junior judges threatened mass resignations. This episode revealed her most surprising strength: the loyalty she inspired in those who believed in justice. "They thought the robe made me vulnerable," she later reflected, "but it was my armor." Today, her principles are being reinterpreted for new challenges: climate litigation, digital rights, and algorithmic bias. A tech startup even created an AI model trained on her rulings to predict ethical outcomes in corporate law. Scholars debate whether she would approve, but her former clerks insist she'd embrace innovation that serves justice. Meanwhile, her handwritten notes from famous cases now form an interactive museum exhibit where visitors weigh moral dilemmas she faced. Most remarkably, communities she never visited quote her maxims in local struggles, from Amazonian tribes resisting deforestation to Tokyo salarymen fighting workplace harassment. Her legacy isn't frozen in law books. It's a living conversation that grows richer with each generation's battles for fairness. Behind her steeled demeanor in court lay years of cultivated mental resilience. Colleagues never saw her flinch during tense proceedings, but her private journals revealed nights of anguish over death penalty cases. She developed a unique ritual. Before pronouncing sentences, she would study the defendant's childhood photos, if available. "One must see the whole person before judging the act," she wrote. When particularly brutal evidence haunted her, she'd visit the crime scenes alone at dawn, needing to understand the human stories behind legal files. Psychologists later studied her ability to compartmentalize trauma while maintaining compassion, calling it judicial mindfulness. Her unshakable presence in court wasn't absence of feeling, but mastery of it, a lesson she imparted to judges dealing with burnout. She revolutionized judicial writing by banning archaic Latin phrases and legalese in her courtroom. "If the people can't understand their justice system, it ceases to be just," she declared. Her landmark rulings read like compelling narratives, opening with vivid context before legal analysis. One famous child custody decision began. This case isn't about parental rights, but about where a 7-year-old will cry for comfort at night. Law schools now teach her accessible jurisprudence method, showing how clear language strengthens the law's legitimacy. Surprisingly, her plain-speaking approach made her rulings harder to appeal. When common citizens could understand them, public pressure kept higher courts from overturning just decisions. Even her critics admitted, she made the law belong to the people again. Trained pianist in her youth, she approached trials with a conductor's precision. She strategically allowed emotional outbursts from victims when the jury needed reminding of human stakes, then restored order with a timed silence more powerful than any gavel strike. Observers noted how she'd physically reposition herself, standing to pronounce life sentences, sitting at eye level when listening to juveniles. Her most theatrical moment came during a corruption trial. When the defendant smirked at victim testimony, she ordered the entire courtroom rotated 180 degrees so he'd have to physically turn to see his luxury yacht docked outside. "Let the symbolism match the substance," she explained. These calculated dramatics weren't for show, but to make abstract justice viscerally felt. Her most radical belief was that judges should measure success not in cases closed, but in harm prevented. She initiated justice audits, tracking what happened to defendants and victims years after trials. Discovering that 60% of released juveniles reoffended without support, she created the first judicial follow-up program pairing them with mentors. When a woman she'd acquitted of killing her abuser later opened a shelter, the judge attended the ribbon cutting anonymously. "We don't just decide cases, we plant seeds," she told her staff. Now, the Gardner principle is transforming probation systems worldwide. Her true legacy grows in the unseen lives changed by her insistence that justice doesn't end at the courtroom doors. She instituted emergency night courts for time-sensitive cases where delayed justice meant irreparable harm: migrant deportations, medical parole appeals, and child removals. Working by lamplight with volunteer attorneys, she heard cases between 10 p.m. and 4 a.m., calling it the shift when power sleeps but injustice wakes. One Christmas Eve, she halted 37 deportations by discovering flawed translations in asylum paperwork. Critics called it grandstanding until footage surfaced of her still in robes at dawn, personally delivering approved medical transfer orders to hospitals. "Bureaucracy keeps office hours," she noted dryly. "Human rights don't." These twilight sessions became legend, inspiring night court initiatives across 12 countries. In a shocking turn, she was charged with contempt after publicly destroying a corrupt warrant during proceedings. The televised trial became the ultimate test of her principles. Would the system she challenged afford her fairness? She conducted her own defense without theatrics, simply walking jurors through each legal precedent. When the prosecutors cited her past dissents as evidence of bias, she responded, "Consistency is not conspiracy." Acquitted unanimously, she returned the next day to preside over the same prosecutor's judicial misconduct case. The photo of them shaking hands post-ruling, her in judicial robes, him in defendant's attire, became the ultimate portrait of justice's impartiality. Her retirement application included a clause to retain one case annually as visiting conscience. Chosen by public vote, these legacy trials addressed systemic failures she'd previously been powerless to fix. At 89, she heard the final case from a wheelchair, oxygen tank beside the bench. The matter? Whether judicial immunity should shield corrupt peers. Her 180-page ruling dismantled the doctrine, creating a whistleblower pathway that toppled 3 Supreme Court justices within months. Dying weeks later, her last words were courtroom instructions to nurses. "Let the record show, I tried." The courthouse bells now toll 20 times every equinox, once for each revolutionary year of her service. She pioneered silent deliberations, days when courtrooms operated without verbal arguments. Attorneys submitted written briefs in advance, while defendants and victims communicated through interactive screens. On these days, the only sounds were the turning of pages and the occasional gasp as truth emerged unfiltered by oratory tricks. One landmark case was decided entirely through exchanged letters between warring siblings, which she had them read aloud silently to each other simultaneously. When we remove performance, she noted, we often find justice hiding in the quiet. This method proved particularly effective in sexual assault cases where victims froze under cross-examination. The practice has since been adopted in trauma-informed courts worldwide. Her most radical innovation was declaring certain judgments open cases, allowing rulings to be incrementally modified as circumstances changed. A child custody decision, for instance, automatically reviewed itself every 6 months via AI analysis of school records and therapist reports. In one famous property dispute, the verdict adjusted itself based on real-time environmental sensors monitoring land restoration progress. Traditionalists screamed about finality of judgments until she demonstrated how 34% of appealed cases involved changed circumstances the original verdict couldn't anticipate. Justice shouldn't fossilize, she argued. Now, living rulings account for 12% of family and environmental cases globally. Beyond rulings, she became known for her unconventional justice pairings, ordering opposing parties to collaborate on solutions. A landlord sued for eviction might be required to co-design affordable housing with former tenants. Corporate polluters found themselves partnering with school children to create environmental curricula. Her most controversial was having a convicted burglar apprentice with a security system designer whose home he'd broken into. The law breaks enough things, she said. It should know how to put some back together. While only 60% of these pairings succeeded, the ones that did created astonishing transformations, including 6 marriages between former legal adversaries. In complex cases, she sometimes flipped the traditional sequence, having jurors first determine what justice would look like, then working backward to see if the facts supported it. This sentencing-first approach particularly shined in corporate crime cases where traditional methods struggled with diffuse responsibility. One pharmaceutical trial began with victims describing what repair would mean to them before any evidence was presented. The eventual $3 billion settlement included novel provisions like funding independent research labs, terms that never would have emerged from conventional litigation. Critics called it result-oriented justice, until studies showed these rulings had 40% higher compliance rates and 72% greater public satisfaction. Her final project was establishing procedures for posthumous testimony, allowing voices from the past to speak through diaries, DNA, and digital reconstructions. In a historic slavery reparations case, she admitted as evidence algorithmic recreations of ancestral voices based on plantation records and oral histories. When challenged, she ruled, "The dead have always testified through documents. We're just helping them speak more clearly." The practice gained acceptance after helping resolve decades-old cold cases through advanced forensic narration. Her own posthumous testimony, drawn from 40 years of journals and recordings, continues to be cited in courts today, making her the only judge whose rulings still evolve from beyond the grave. She abolished static seating arrangements, designing courtrooms with rotating platforms that physically reposition participants based on evolving testimony. Defendants found themselves moving closer to victims during apologies, experts orbiting juries during technical explanations. In one emotional restitution case, the entire space slowly tilted 15 degrees whenever statements became dehumanizing, creating physical unease that mirrored moral discomfort. "Architecture teaches what words cannot," she explained. These kinetic courtrooms reduced recidivism by 22%. Participants reported the bodily experience of fairness lingered longer than memories of legal arguments. Her most controversial innovation introduced scent diffusion systems that released carefully curated aromas during proceedings. The smell of fresh bread accompanied witness testimony, lavender oil misted during jury deliberations, and, most shockingly, the faint odor of burning rubber when lawyers made logical fallacies. While initially decried as manipulative, brain scans prove these olfactory cues improved truth discernment by 37%. The practice gained acceptance after exonerating an innocent man when jurors reported his authentic testimony smelled different from fabricated accusations. "The nose knows what the mind overlooks" became her unexpected judicial maxim. She established a parallel court of judicial integrity, where retired jurists anonymously reviewed their peers' ongoing cases. These shadow evaluations, visible only to the presiding judge, created unprecedented accountability. One powerful magistrate resigned after receiving 87 consecutive ethical deviation alerts. The system's brilliance lay in its discretion. Critiques appeared as margin notes in the judge's personal copy of case files, written in disappearing ink that faded after 24 hours. Accountability works best when it educates rather than humiliates, she noted. The program reduced judicial misconduct complaints by 63% within 5 years. Her team developed an AI model that identified defendants likely to redeem themselves given specific rehabilitative conditions. The algorithm didn't recommend sentences, but proposed individualized mercy pathways. One burglar needed carpentry training, another required dialectical behavioral therapy. Judges remained free to reject suggestions, but 89% of algorithm-supported rulings produced dramatically better outcomes. The system's true innovation was its reverse engineering function, showing precisely what combination of support and accountability would maximize each person's potential. It proved particularly effective for juvenile cases, reducing repeat offenses by 76%. Her final radical concept was time-limited judgments, rulings designed to automatically expire unless renewed. A business regulation might sunset in 5 years unless its benefits were reconfirmed. A custody arrangement could require periodic reaffirmation by the now older child. This created what she called justice with built-in humility, acknowledging that social contexts evolve. The approach revolutionized administrative law, with 42% of expiring regulations allowed to lapse as circumstances changed. Her most poignant application was in wrongful conviction cases. Compensation packages that adjusted annually based on the ex-offender's actual rehabilitation progress rather than one-time lump sums. Her legacy redefined justice not as a rigid system, but as a living, breathing force, adaptable, sensory, and deeply human. From midnight courts to expiring verdicts, she taught us that true fairness requires both courage and humility. The courage to challenge power, and the humility to know the law must evolve. Though her robes now hang in a museum, her vision endures wherever justice bends toward mercy, truth rises above procedure, and the powerless find their voice. The gavel may fall, but justice never stops growing.